الجامعة الإفتراضية السورية كتاب Criminal Law القانون الجزائي by عماد الدين محمد. الوحدة التعليمية السادسة Chapter 6 يغطي هذا التسجيل الشرائح من 32 وحتى النهاية. Slide 32 until the end. Slide 32 No defense of irresistible impulse. للاطلاع It is no defense for a defendant to argue that he acted under an impulse which he could not control due to a defect of reason caused by a disease of the mind. This defense was rejected by the Court of Appeal in the case of Kopch 1927, 19 CR APP R50, in which the defendant killed a relative by strangling her. He argued that at the time of the offense, he had lost conscious mind and acted subconsciously. The Court of Appeal rejected this defense of uncontrollable impulse. It was also rejected in the case of Sodman, VR 1936 to All ER 1138, when it was known as irresistible impulse. The McNaughton rules are clear that where the defendant understands the nature and quality of his act and know that his act is legally wrong, he will not be able to rely upon the defense of insanity. Where the defendant is charged with murder, he could plead the partial defense of diminished responsibility under Section 2 of the Homicide Act 1957. Slide 33 Reform للاطلاع. Please note that the McNaughton rules have been subject to criticism and there have been many calls for reform of the law in this area. The McNaughton rules were created by the judiciary rather than those in the medical profession who may have been better qualified to define the defense. Dating from 1843, the rules are over 169 years old and their terminology is archaic. In its report of the Butler Committee on Mentally Abnormal Offenders in 1975, the Butler Committee proposed reform of the law and the creation of a new defense of mental disorder with a verdict of not guilty on evidence of mental disorder, when argued successfully. This new terminology was designed to move away from the stigma attached to the defense of insanity of being labeled insane. This proposal was incorporated into the Law Commissioner's draft criminal code, but Parliament has yet to give effect to any proposed reforms with a view to identifying a more modern test. Students should check on current progress regarding this. Slide 34 Automatism. Automatism, also known as non-insane automatism, is a general defense available in relation to any criminal damage. Insanity, also known as insane automatism, and automatism are similar defenses as both involve situations where a defendant is unable to control his actions or is unaware of what he is doing. Automatism was defined by Lord Denning in the case of Bratty v. Attorney General for Northern Ireland, 1963 AC 386. Between quotation marks, an act which is done by the muscles without any control by the mind, such as a spasm, a reflex action, or a convulsion, or an act done by a person who is not conscious of what he is doing, such as an act done whilst suffering from concussion or whilst sleepwalking. Slide 35 Automatism للاطلاع. So if the actus reus of a criminal offense has to be performed voluntarily, then where the defendant is compelled or forced to perform the actus reus due to some external factor, his conduct is involuntary. Such a defendant will usually lack the mens rea of the offense and will have the defense of automatism, non-insane automatism, as open to him. However, as committing an offense whilst sleepwalking amounts to insanity instead of automatism, the inclusion of sleepwalking in Lord Denning's quote should be ignored. Defense of automatism. The defense of automatism is available where 1. The defendant is not in control of his actions, or 2. The defendant is unaware of what he is doing. Slide 36. Automatism للاطلاع. 1. Total loss of voluntary control. For the defense of automatism to be successful, the defendant must suffer a total loss of voluntary control. Where he still has some control, the defense will fail. 2. Involuntary conduct due to an external factor. The involuntary conduct of the defendant may be due to an external factor. If the factor which causes the involuntary conduct is classed as a disease of the mind, an internal factor, the defense of insanity will be available instead. Where an external factor is happening to the defendant at the time of the criminal offense, he will have the defense of automatism available to him. External factors usually involve a one-off incident, and as such the prohibited conduct is not likely to recur. 3. Reflex action or muscle pain. A defendant who involuntarily commits a criminal offense through a reflex action or muscle spasm will have the defense of automatism available to him. Slide 37. Automatism للاطلاع. Physical force. Where the conduct of the defendant is physically forced or compelled by another, the defendant will be able to plead automatism to any criminal offense which results. For example, if the defendant is pushed into a glass window which breaks, the defendant will not be liable for the criminal damage because his conduct was not voluntary. Diabetes. Hypoglycemia. A defendant who suffers from diabetes and commits a criminal offense whilst in a hypoglycemic state may rely upon the defense of automatism. Hypoglycemia is a condition where the blood sugar level in the body is low and is caused by excess insulin. The case of Quick and Paddison, 1973, QB 910, confirms that hypoglycemia amounts to automatism. See also the cases of Bingham, 1991, Crim LR 433. Contrast this case with the case of Hennessy, 1989, who suffered a hyperglycemic attack caused by his failure to take insulin. As the defendant's hyperglycemia was caused by an internal factor, the condition of diabetes, rather than an external factor, the insulin, the defendant could only plead insanity. Slide 38. Automatism للاطلاع. Post-traumatic stress disorder causing a dissociative state. A defendant suffering from a dissociative state caused by an external factor may plead automatism. Dangerous drugs and non-dangerous drugs. The courts have drawn a distinction between dangerous drugs and non-dangerous drugs. A drug is dangerous if it is common knowledge that the drug may cause the defendant to become aggressive or do dangerous acts. If the defendant's automatism is caused by a dangerous drug, the defendant will have no defense to crime of basic intent, although he may use evidence of his intoxication to negate the mens rea for a specific intent crime. If the automatism is caused by a non-dangerous drug, the defense of automatism will be available to the defendant, provided he was unaware of the risk of becoming an automaton. Basic intent. A crime of basic intent is one which can be committed with a lesser form of mens rea than intention. In other words, recklessness. A crime of a specific intent is one which requires intention as the mens rea. Slide 39. Automatism للاطلاع. Dangerous drugs. If the automatism is caused by the voluntary consumption of a drink or dangerous drugs, the rules relating to the defense of intoxication apply, as set out by the House of Lords in the case of DPP v. Majewski, 1977, AC 443. This means that automatism will not be a defense to a basic intent crime, although it may be a defense to a crime of a specific intent. See case of Lippmann, 1970, 1 QB 152. Non-dangerous drugs. Where the automatism is caused by non-dangerous drugs, the defendant will be able to plead automatism, provided he was unaware of the risk of becoming an automaton. See the case of Bailey, 1983, 1 WLR 760. Slide 40. Intoxication. Intoxication is not a defense as such, as for policy reasons, the courts do not like the use of intoxication, in particular voluntary intoxication, as a means of escaping criminal liability. However, a defendant may argue that due to his intoxicated state, he did not have the mens rea for the offense charged. So, intoxication is evidence which may negate the mens rea of an offense and may be evidence in support of a defense rather than constituting a defense in itself. Slide 41. Involuntary intoxication. Involuntary intoxication may be a defense to any offense if the defendant does not have the mens rea for the offense in question. Intoxication will be regarded as involuntary if the defendant is not aware that he is consuming alcohol or drugs, or the defendant who is not at fault in taking the drug is unaware of the effect it will have on him. Examples are if the defendant has had his drink spiked or laced, someone has put a drug into his drink without him knowing, and he has become involuntarily intoxicated, or where he takes a drug prescribed for him in accordance with the prescription, or where he is not at fault in taking a non-dangerous drug. Even where the defendant is involuntarily intoxicated, his intoxication will only provide a defense where he does not have the mens rea for the offense. If there is clear evidence of the mens rea, the defendant will have no defense. Slide 42. Involuntary intoxication للإطلاع. See the case of Kingston, 1952, 2 AC 355. Defendant was charged with indecent assault against a 15-year-old boy, but he claimed that his drink had been spiked or laced and he remembered nothing other than seeing the boy on the bed. The trial judge directed the jury that they should convict the defendant if they were sure that despite his intoxication state, he intended to commit indecent assault. The defendant appealed against the conviction. The House of Lords confirmed the trial judge's direction and held that a drugged intent is still intent. So if the defendant intended to commit indecent assault, he had the requisite mens rea for the offense, and this could not be negated by his involuntary intoxication. This same principle was applied in the earlier case of Sheehan and Moore, 1975, 1 WLR 739, in which the Court of Appeal held that a drunken intent is still an intent. Where the defendant voluntarily takes a prescribed or non-dangerous drug and is not reckless in doing so, he will be able to rely on his involuntary intoxication to negate his mens rea, provided there is no compelling evidence that he formed the necessary mens rea. This principle was laid down in the case of Hardy, 1985, 1 WLR 64 by the Court of Appeal, where a defendant voluntarily consumes an alcoholic drink but believes the alcoholic content to be lower than it is, he will not be able to argue that he was involuntarily intoxicated, as he still chose to consume an alcoholic drink. See the case of Allen, 1988, Crim LR 698. Slide 43. Voluntary intoxication. Where the intoxication is not involuntary, it will be voluntary, and the rules laid down in the leading House of Lords authority of DPP v. Majewski, 1977, AC 443 will apply. According to this case, voluntary intoxication is no defense to a basic intent offense. However, if a defendant may use evidence of his voluntary intoxication at the time of the offense to negate the mens rea of a specific intent or offense, by arguing that due to his intoxication he did not, in fact, form the necessary intention and so is not liable. Slide 44. The rules in DPP v. Majewski للاطلاع. DPP v. Majewski, defendant was involved in an altercation in a pub during which he punched a customer in the face, cut the landlord with a piece of broken glass, and struck a police officer. He was charged with assault occasioning actual bodily harm, contrary to Section 47 of the Offences Against the Person Act 1861, and assaulting a police officer in the execution of his duty. The defendant had taken a mixture of drugs and alcohol prior to the incident. He argued that due to his intoxication, he did not know what he was doing and he did not form the mens rea for the offenses charged. The trial judge rejected intoxication as a defense and the defendant was convicted. On appeal, the case reached the House of Lords, who held that evidence of voluntary intoxication cannot be used as a defense to a crime of basic intent. However, evidence of voluntary intoxication may be used as a defense to a specific intent crime if the intoxication negates the mens rea of the offense, in other words, intention. The decision in this case was mainly based upon policy reasons. The House of Lords was concerned that allowing intoxication as a defense would undermine the criminal law, one of the prime purposes of which is the protection of the public from violent behavior. So in order to protect the community, the mens rea of a basic intent offense will not be negated through proof of voluntary intoxication. Lord Elwin Jones LC gave the leading opinion in the House of Lords, and he took the view that a defendant who voluntarily becomes intoxicated should be criminally liable for his conduct while he is in such a condition. Slide 45. The rule in DPP v. Majewski للاطلاع. He famously stated, if a man of his own volition takes a substance which causes him to cast off all restraints of reason and conscience by holding him answerable criminally for any injury he may do while in that condition, his course of conduct in reducing himself by drugs and drink to that condition, in my view, supplies the evidence of mens rea, of guilty mind certainly sufficient for crimes of basic intent. It is a reckless course of conduct, and recklessness is enough to constitute the necessary mens rea in assault cases. Slide 46. Specific intent and basic intent offenses. As the decision in DPP v. Majewski focused heavily on the nature of the offense charged as one of specific intent or one of basic intent, it is important and necessary to have an understanding of the distinction between these terms. There is no clear authority on their meaning, and the term specific intent was first used by Lord Birkenhead in the House of Lords decision in DPP v. Bird 1920 AC 479. It is unlikely that the term was intended to become as important as it did in the later authority of DPP v. Majewski and since that case. A crime of a specific intent is one which requires intention as the mens rea. In other words, murder as it is a crime of specific intent as the mens rea is intention to kill or cause GBH, grievous bodily harm. Intention must be proved. Recklessness would not be sufficient. A crime of basic intent is one which can be committed with a lesser form of mens rea than intention, in other words, recklessness. Example: criminal damage is a crime of basic intent as the mens rea requires intention or recklessness to destroy or damage property, so a defendant can be convicted if he is merely reckless as to whether property would be destroyed or damaged. Slide 47. Dutch courage للاطلاع. A defendant who deliberately consumes alcohol or drugs in order to gain the confidence to commit a criminal offense may not rely upon evidence of his intoxication in order to negate the mens rea of the offense. This was confirmed by the House of Lords in the case of Attorney General for Northern Ireland v. Gallagher, 1963, AC 349. Lord Denning stated that, between quotation marks, the wickedness of the defendant's mind before he got drunk is enough to condemn him, coupled with the act which he intended to do and did do. Such a defendant clearly has the intention to commit the offense. End of quotation. Such a defendant clearly has the intention to commit the offense and cannot evade liability by pleading intoxication, which was induced to give him the courage to do so. The defendant's intoxication provides no defense even to a crime of a specific intent. Slide 48. Intoxication and defenses للاطلاع. It is important to consider the impact of intoxication upon the defenses in criminal law. Where a defendant who is drunk wishes to raise a defense, how will his intoxication state affect his defense? In order to answer this question, we need to consider each of the defenses separately. 1. Mistake. A defendant's intoxicated mistake will not negate the defense of lawful excuse under Section 5.2 of the Criminal Damage Act 1971 to a charge of a criminal damage. The defendant will still have the defense available to him. The authority for this is the case of Juggard v. Dickinson, 1981, QB 527. The defendant, whilst drunk, broke into somebody's house, believing that it was her friend's house. Her friend had given her permission to treat his home as her own, and after a night of drinking, the defendant tried to break into what she thought was her friend's house. The defendant's defense was that she held a mistaken but honest belief that her friend would have consented to the damage she caused if she had targeted his house. The divisional court held that the defendant could rely upon her mistaken but honest belief in her defense, even though her mistake was induced by intoxication. Slide 49. Intoxication and defenses للاطلاع. 2. Self-defense. Where a defendant mistakenly acts in self-defense, but that mistake is induced by the defendant's intoxication state, self-defense will be no defense. O'Grady, 1987, QB 1995, and O'Connor, 1991, Crim LR 135. This principle has been subject to criticism because where an intoxicated defendant who kills A may escape liability for murder if he lacks the relevant mens rea for that offense. An intoxicated defendant who kills due to a mistaken belief that he is acting in self-defense may not rely upon his intoxicated mistake in his defense. 3. Duress. Duress requires that the defendant has reasonable grounds for believing that there is a threat to his life or one of serious physical injury to him. If that belief is induced by intoxication, the defense of duress will not be available to the defendant. 4. Automatism and insanity. Where the defendant's intoxication induces a state of automatism, the defendant may not rely upon the automatism. The relevant defense is intoxication. Where the intoxication induces a disease of the mind, the defendant may have the defense of insanity available to him. This will be dependent upon the remainder of the McNaughton rules. Slide 50. Intoxication and defenses للاطلاع. 5. Provocation. Where the defendant is provoked to kill because the defendant mistakenly believes that things have been said or done, or both, he will still have the defense of provocation open to him. This is so even if the mistake was induced by his intoxication. In relation to the final limb of provocation, whether the defendant acted as a reasonable man would have done, intoxication is not a factor to be taken into account. 6. Diminished responsibility. Cross-reference. The impact of intoxication upon the defense of diminished responsibility was explored in the chapter on murder and voluntary manslaughter. Slide 51. Reform. للإطلاع. The Law Commission published a report on intoxication and criminal liability, Law Com. number 314, on the 15th of January 2009, making recommendations to clarify the terms of specific intent and basic intent used to make them comprehensible, logical, and consistent. Slide 52. Mistake. Generally, ignorance of the law is no defense to a criminal charge. A defendant's mistake as to the criminal law will not usually absolve him of liability. Example: if a defendant, unaware of the speed limit in England, drives up the motorway at 100 meters per hour, it is no defense for him to claim that he mistakenly believed that the speed limit was 100 meters per hour. However, mistake may provide a defense in three scenarios. 1. Where the mistake relates to civil law and negates the mens rea of the offense. 2. Where it relates to a fact and negates the mens rea of the offense. 3. Where the mistake relates to a defense element. Slide 53. Mistake as to civil law. للإطلاع. A defendant's mistake as to civil law may provide a defense if it negates the mens rea of the offense. This is illustrated in the case of Smith, 1974 QB 354. The defendant was renting a flat and he was given permission by his landlord to install roofing material and wall panels and to lay floorboards in the flat. At the conclusion of his tenancy, the defendant damaged the roofing, wall panels, and flooring in order to access some electric wiring he had installed for his music system. He was charged with criminal damage. Under civil law, the roofing, wall panels, and flooring had become the property of the landlord upon being fixed to the flat. The defendant was unaware of this and claimed that he thought he was damaging his own property. His conviction was quashed by the Court of Appeal. The Court of Appeal held that the defendant's mistake as to the civil law negated his mens rea, as he did not intend to damage property belonging to another. Slide 54. Mistake as to fact. للإطلاع. A defendant's honest mistake as to fact may provide a defense by negating the mens rea of the offense. Example: where a defendant appropriates property belonging to another, mistakenly believing it to be his own, he is not guilty of theft provided his mistake is an honest one. His mistake as to fact here negates the mens rea of the theft. The defendant is not dishonest if he honestly believes that he has a right in law to the property. The leading authority on mistake as to fact is DPP v. Morgan 1976 AC 182. In this case, the House of Lords held that an honest but mistaken belief in consent is sufficiently as defense to a charge of rape. The belief had only to be honestly held and it did not need to be a reasonable one. The defendant's mistaken belief as to an actus reus element of the offense negates the mens rea of the offense. However, in relation to sexual offenses, a defendant's mistake as to consent must be both honest and reasonable. Although a mistake generally only has to be honestly held in order to negate the mens rea of offense, the case of Tolson 1889 23 QB 168 required a mistake to be both honest and reasonable. However, this authority has recently been disproved by the House of Lords in the case of B. A. Minor v. DPP 2002 2AC 428, in which the House of Lords held that the defendant's mistake as to the complainant's age was a defense if it was honestly held. The mistake did not also have to be a reasonable one. Slide 55. Mistake as to a defense element للاطلاع. This paragraph deals with situations where a defendant makes a mistake as to defense element. Example, where a defendant would have had a defense had the facts been as he believed them to be. The question of whether his defense is still valid despite the mistake depends upon the defense relied upon and whether the mistake is honestly and/or reasonably held. Defenses may be divided into justifications and excuses. Justificatory defenses negate the mens rea of the offense. Excusatory defenses do not negate the mens rea of the offense, but they excuse the conduct of the defendant. Slide 56. Mistake as to a defense element للاطلاع. Self-defense. Self-defense is a justificatory defense. Where the mistake is made as to a justificatory defense, the mistake need only be honestly held. So a defendant who mistakenly believes that he needs to use force to defend himself will still be able to rely upon self-defense, provided his mistake was an honest one. See the case of Williams, Gladstone, 1987, 3 all ER 411. The defendant is judged on the facts as he honestly believed them to be. Duress. Duress is an excusatory defense. Where the mistake is made as to an excusatory defense, the defense must be both honest and reasonable. A defendant who intentionally commits an offense under the mistaken belief that he is being coerced into doing so will still be able to rely upon duress. According to the case of Graham 1982-74 CRAPPR 235, the defendant's belief in the existence of the threat of death or serious injury needed to be both honest and reasonable. This was approved by the House of Lords in Ho 1987 AC 417, but both statements were obiter dicta. More recently, in Hassan 2005, UKHL 22, Lord Bingham stated that the defendant's belief in the threat must be both honest and reasonable. Slide 57. Summary للاطلاع. A general defense is one which a defendant may plead in relation to any criminal offense. For example, insanity, automatism, self-defense, and mistake. A special defense may only be pleaded in relation to specific offenses. Examples, provocation and diminished responsibility. Children under the age of 10 are conclusively presumed to be dully incapax. Insanity, insane automatism, is concerned with the mental condition of the defendant at the time that the offense was committed. It leads to a special verdict of not guilty by reason of insanity. The defendant must prove on a balance of responsibilities that at the time he committed the act, he was, between quotation marks, laboring under such a defect of reason from disease of the mind as not to know the nature and quality of the act he was doing, or if he did know it, that he did not know he was doing what was wrong. End of quotation. McNaughton Rules 1843. Slide 58. Summary للاطلاع. Automatism is available where the defendant suffers a total loss of control over his actions or he is unaware of what he is doing. Automatism is dependent upon some external factor acting upon the defendant at the time of the actus reus, whereas insanity requires proof of an internal factor, a disease of the mind. Involuntary intoxication may be a defense to any offense provided that the defendant does not have the mens rea for the offense in question. A drugged intent still amounts to intention. Kingston 1995. Voluntary intoxication is no defense to a basic intent offense. It may be used to negate the mens rea of a specific intent offense if, due to his intoxication, the defendant did not form the necessary intention. DPP v. Majewski 1977. A mistake as to civil law may provide a defense by negating the mens rea of the offense charged. Smith, 1974. A mistake as to fact may negate the measure of an offense if it is honestly held. DPP v. Morgan, 1976, and B. A minor v. DPP, 2000. Slide 59. Questions. 1. What is the age of criminal responsibility? 2. What are the elements of insanity? Cite an authority for this. 3. What is a disease of the mind? Cite an authority. 4. When may a defendant plead non-insane automatism? 5. What defense is available to a defendant who commits an offense whilst in a hypoglycemic state? 6. What defense is available to a sleepwalking defendant? 7. Explain the key differences between insanity and automatism. 8. Is self-induced automatism a defense? 9. Explain the rule in DPP v. Mayovsky, 1977. 10. When is a mistake a defense? Slide 60. Note للإطلاع. It is very important that students are able to distinguish and learn between the two different words below which sound similar but are spelled differently. Each word means a different type of condition in diabetes, which is important in law. Please note the difference in the spelling and what each one means both medically and in the law. The first word is hyperglycemia, and the second word is hypoglycemia. End of chapter 6. نهاية التسجيل ونهاية chapter 6. تقدمت مبادرة ضوء بصوت دانة بيرقدار.